Yes.
May I please? Lordship, I beg to mention item 9, 10, and 11 of admission. This is analogous method. Lordship, personal difficulties. So I have this matter to be listed after 2 weeks. I've informed the other side also.
Mr. Kilolin, Direct Counsel for the petitioner with the consent of submit that he has personal difficulties to raise and therefore prayed for adjournment. He has also obtained consent from the other side. He is prayed come. He is prayed come at least this matter after 2 weeks.
There is interim order, Lordship.
What interim order is there?
Interim, Lordship, there is no course of action against the applicant.
In this case?
Yes, in 3 cases.
No course of action. Why is so that? What are dated?
Order, Lordship. Exact that I don't remember.
Okay. So the interim order, if any, shall continue till the next date. Okay.
Deeply obliged.
My lord, my lord, item seeking adjournment for
Item
number 7 with the consent of the party. Lord, the conducting counsel is out of his station.
You are Mr.
Kodapa.
Direct Counsel appearing on behalf of Direct Counsel submits that the conducting counsel is out of station and therefore prayed for adjournment of the matter. Have you informed the other side?
Yes,
sir.
yes, appearing.
To which Mr.
Ring.
Direct Counsel appearing on behalf of the respondent has not. Putting the prayer, list this matter after
4 weeks, my lord.
4
weeks.
4 weeks. Okay.
Interim may be continuing.
There is interim.
Yes. Because in similar situated matter, where we have challenged the WPC, which is pending
The
report.
interim order passed earlier will continue till the next date. Okay.
Grateful.
Your Lordship, I beg to mention item number 5, appearing on behalf of Digi Pangin.
Item
5, Your Lordship. Due to some personal difficulties, he is not able to argue the method.
You are Mr.
Sita Jo.
And who appeared for
Sita Jo.
who appears for the other side?
Your Lordship, R. Kia.
Have you informed?
Yes, Your Lordship.
Okay. Mr. Chigajo, Land Council submits that the conducting council has some personal difficulties today and therefore pray for adjournment. He has also obtained that consent from the Land Council appearing on behalf of the other side. So, he prayed, comma.
2 weeks, Your Lordship.
After 2 weeks?
Yeah.
Let the matter be listed after 2 weeks.
Your Lordship, one more item. Item number 25.
25.
Your Lordship, kindly this matter may be fixed on 27 May.
27.
May.
Here also you have informed the other side.
Yes, Your Lordship.
Similar order. Okay.
Obliged.
My lord, I beg to mention item numbers 24. Item number 24 on the behalf of Etatak. And
Behalf of?
Etatak. And my lord said conducting counsel is out of his station. And my lord, I have taken consent from other parties. So my lord, the matter may be fixed after 4 weeks.
You are Mr.
T. Gambi, my lord.
Direct Counsel submits that the conducting counsel is out of the station, therefore pray for adjournment. He has also obtained a consent from the Land Council appearing on behalf of the other side. Accordingly, the prayer is allowed. List this matter after 4 weeks. Okay.
Master Blake.
My lord.
Yes.
My lord, I beg to mention item number 20 on behalf of
20.
yes, on behalf of this for the petitioner.
It is order.
Yes, my lord. He's out of this session.
Service complete.
My lord, he just now instructed me to take an adjournment because he went out of the station due to some emergency.
Grant to prayer. Let us see the order. Okay. Wait for some time.
My lord, one more item number 22 on behalf of K lawyer. Matter by kindly list up to 3 weeks.
Have you informed the other side?
My lord, I tried to contact, could not contact to them. I will inform them.
Mr. Krishna,
P. Harming.
you are
P. Harming.
current counsel appearing on behalf of the
Yeah, lawyer.
lawyer is out of station.
No, my lord, this is different matter. He, due to some personal difficulties, he could not appear.
The learned appear and learned conducting counsel has some personal difficulties to raise. And therefore pray for adjournment of the matter. For
3 weeks. And
current counsel also, Mr. Gill informed the
others.
other side.
My lord, there is an interim
Therefore,
order,
let the matter be listed after
3 weeks.
3 weeks.
And there is an interim order.
Interim, the interim order passed earlier shall continue to the next day of listing. Okay.
Deeply over.
Lordship, I would like to mention for unlisted matter, Your Lordship. This is IA number 39/2025, Your Lordship.
I, what, for
This is IA related to the quashing application, Your Lordship. In main petition, we have missed out the prayer for staying of trial, Your Lordship.
Hmm?
We have missed out the prayer for trial.
it is to be mentioned before the senior page or it can be mentioned. Passing petition, huh?
Lordship,
Mention is to be made before the senior bench or this. Senior. The mention, you make a mention before the senior bench, right? Unlisted,
yes, sir.
you have to make a mention before the senior bench. Okay.
Yes, sir, yes, sir.
May your lordship please.
Yes,
I beg to mention item number 12. I'm on behalf of Learned Counsel G. Kato. I'm for appellant.
what do you want? What is your prayer?
G. Kato.
Okay.
Sorry.
What is your prayer?
Oh. I'm praying for adjournment.
Adjournment.
Yes, your lordship.
Who appears for the other side? Have you informed the learned counsel appearing on
Yes,
behalf?
yes, your lordship.
Okay. Miss,
Why Giba?
Hmm?
Why Giba?
appearing on behalf of
G. Kato.
Mr. G. Kato. With, and with the consent of the learned counsel for the other side, prays for adjournment of the matter. So how, so your pray for adjournment is for how much time?
4 weeks. 4
Four?
weeks. 4 weeks.
4 weeks. 4 weeks. The prayer is enough. List this matter after 4 weeks. Okay.
Much obliged.
Your Lordship, I beg to mention item number 6. This matter may be listed after 2 weeks, Your Lordship.
After,
2 weeks, Your Lordship.
why?
Uh,
You are for?
a respondent, Your Lordship.
You are for respondent.
Yes, Your Lordship.
Who is for the petitioner? Petitioner. Okay, after 2 weeks, on the joint prayer made by both the learned counsel for the parties, list this matter after 2 weeks. Stop, para. The interim order passed earlier shall continue to the next stage of listing. Okay.
Obliged.
May I, Lordship? Lordship, I beg to mention item number 8. Lordship, kindly matter may be adjourned after 2 weeks.
Why?
As the conducting counsel is Guwahati, however, due to some personal difficulties, he is unable to appear before this court.
You are for the petitioner.
Yes, Your Lordship.
Conducting counsel
Is unable to appear due to some personal difficulties.
okay. You are for?
M. Kato,
Okay, no objection.
correspondent. No.
Okay. Miss,
N. Honde. N. Honde.
learned counsel appearing on behalf of Mr. Ninja Army. Land Council for the petitioner, prays for adjournment of the matter for
After 2 weeks.
2 weeks. Miss,
you-
your good name,
Yasmin Gav.
Hmm?
Yasmin Gav.
appearing on behalf of the respondent as not. Accordingly, the prayer is allowed. This matter after 2 weeks. Okay.
Your Lordship, there is an interim which may be continued.
The interim order passed earlier should continue to the next year of this. Okay.
Deeply obliged, Your Lordship.
My lord, I would like to mention item number 15.
15.
Yes, yes, my lord.
Therefore,
Petitioner.
petitioner,
Yes.
why you want adjournment?
And due to some personal difficulties of my counsel.
Who has personal difficulties?
Miss T.Y. Bhutia.
Hmm?
T.Y. Bhutia.
You're Mr.
N. Nyodu.
Land Council, submits that the conducting council, Mr. T.Y. Bhutia. Land Council for the petitioner has some personal difficulties today and therefore prays for adjournment. The prayer is allowed. Is this matter after
4 weeks.
4 weeks?
My lordship, I'd like to mention the unlisted 2 bail application, which is very urgent. So, Madam, fix today for the just holding of CD.
Bail application is.
Yes.
Okay. Is the last item.
I'd like to mention that one pending agreement petition, which is matter may be fixed for tomorrow.
Tomorrow.
Yes.
Okay. Tomorrow? Tomorrow's list they have already prepared. Day after tomorrow.
This is civil revision petition filed under Article 227 of Indian Constitution. Lord, the first let's go the synopsis of the case. Synopsis of the case, civil revision petition. So the fact of the case is that on 27/4/2024, respondent number 2 filed a complaint before the respondent number 1, circle officer, Gumto Circle, District Papumpare, Arunachal Pradesh, alleging against petitioner number 2 that petitioner number 2, D then GB of Bogli Place, had illegally sold his plot of land to the petitioner number 1, and to which on the 29/4/2024, the circle officer, instead of in the complaint petition to the head Ganpura of Bogli Place, inadvertently endorsed the said complaint application to respondent number 2 and 3, that is, who is the place authority of Denka Village, for amicable settlement. But on the 6/5/2024, a mail notice was served to petitioner number 2 only by respondent number 3, 4, and 5, that is village authority of Denka Village, requiring their attendance on the 11/5/2024, to which the petitioner number 2 on 8/5/2024 submitted a reply clarifying the actual fact of the said dispute land and informed his inability to attend the same on health ground. On the 12/5/2024, the village authority of Denka inadvertently and arbitrarily forwarded the matter to the apex customary court in the name of all Arunachal Pradesh Ganwara and Ganguri Welfare Association without giving reasonable opportunity of being heard to the petitioner number 2. On 16/5/2024, respondent number 6, President, all Arunachal Pradesh Ganwara and Ganguri Welfare Association, an association which is not a village authority, their office, which on submission of application dated 24/5/2024 by the petition number 1, requesting adjournment was refixed on dated 15/6/2024. Interestingly, my lord, on dated 15/6/2024, in the letterhead of EPIC's customary but arbitrarily presided by signed by president of another body called All Arunachal Pradesh Ganbura and Ganbura Welfare Association, declared the title, ownership, and possession of the disputed land in favor of respondent number 2, misinterpreting the statement of one Srimati so and so as a witness. Consequently, based on such judgment, dated 15/6/2024, the EPIC's customary court had issued a copy of decree on dated 16/6/24, to which the respondent number 2 moved in execution petition before the Court of Deputy Commissioner Papumpare UPA Arunachal Pradesh on dated 21/2/2025 through his counsel. Therefore, finding violation of the provision of Assam Frontier Administrative Justice Regulation 1945 and Amendment Act 2023, as well as Arunachal Pradesh Civil Court Amendment Act 2022 and 23. Hence, this civil revision petition under Article 2 to 7 of Indian Constitution, my lord. My lord, here in this case, there is total of 10 respondents. 10 respondent. Number 1 is the circle officer, Gumto Circle of Papumpare district, and respondent number 2 is one Dilip Thadap, who has encroached the land of the petitioner number 1, and thereafter he filed an application before the circle officer, Gumto Circle, for endorsing the for mail order, whereas the circle officer has to endorse the complaint letter to the Bogli village. The dispute land falls under the Bogli village, not in the Denka, but circle officer endorsed to not, instead of endorsing the village authority of Bogli, endorsed to the Denka village of Gumto Circle.
The property is located in
Bogli village. Bogli.
under
Gumto Circle.
Gumto Circle.
Gumto Circle nearby the lordship near Doimokonde.
The complaint was filed before the
CO. CO endorsed the letter instead of endorsing to the Bogli village where jurisdiction for dispute files. He endorsed the letter to the Denka village.
Why you have included these GBs?
Lordship.
Who are these GBs?
Then GBs, now I'll come to the point. Lordship, here respondent number 1 is circle officer, and respondent number 2 is a GB, Dilip Thadap, and respondent number
GB. Why you have included him?
Now I'll come to the point. Why I implemented GB?
Yes.
Because they are the respondent. The GB is the respondent, and he is the person respondent to the GB. He is the person who complained lodged against the petitioner 1.
Okay.
Petitioner 1.
GB is the party.
Party, yes.
Okay.
GB is party. He himself is party.
Which GB is the party? Respondent number 2.
Respondent number 2 is a GB, and respondent number 3, 4, 5 is GB of Denka. 3, 4, and 5 is GB of Denka, and respondent number 2 is he himself is a GB of the.
How they are connected with the property? This G 3, 4.
Now
5.
I'll come to the final. Fact of the case. Later come to. Lordship, page 10, para 3. The petitioner number 1 is a social worker since from his youth place. Para 3, Lordship. Page 10. Youthful age. The petitioner number 1 is
page 10.
Page 10, para 3.
Hmm.
The brief fact of the case is that the petitioner 1 is a social worker since from his youth age. The petitioner 1 self-acquired a plot of land measuring 81,002 square meter.
That is true. What I'm asking, my question is why you have included respondent number 4, 5, and 6. They seems they are GB.
Lots of GB.
Are they connected with the disputed property?
No, matter was referred to the circle officer.
These are the GB to whom the circle officer referred to for the for decision.
Lordship, then
they are the person who have decided.
Lordship, then they refer the matter. Instead of instead of trial in their village level, they have referred the matter to Apex Customary Court. Endorsed to the letter
Refer the matter in what capacity?
on behalf of the GB only, without trial. Without trial, because they have to trial within the circle of the Gumto circle. Instead of trying there at Bugli, Denka, they have referred a matter to Apex Customary Court at Bandardeva circle. So Bandardeva circle in the name called all
So-
Arunachal.
So because they have referred the case to Bandardeva circle, that
Yes.
is why you have made them as a party.
Yes, Your Honor, yes. Yes.
So, but then your first allegation is that CO has made or CO has referred the matter to this respondent instead of referring the matter to the GB of the village where the property is.
Bogli.
It's a CO only who should be the party. Why GB?
GB, why? I mean,
GB has endorsed whatever may be. GB has endorsed in the capacity of judge only while functioning as a GB under Civil Court Act, isn't it?
now
Are the
they,
necessary party?
yes, later, they are party also.
How they are necessary? party?
Because they have, without giving opportunity, they have referred the matter, the dispute, the case, instead of conducting Kebang to the Apex Customary Court, either or Arunachal Gangwar Reparation Bandardeba. So now, what's it? Now, page number 50, what's it? Come to the page 50. This is the notice issued by this village authority of
Page
page 50.
50.
Yes, sir. NSLG. This is the letter issued by respondent number 3, 4, and 5. 3, 4, and 5. To petitioner number 2. Whereas petitioner 1 is the actual landowner. Without serving notice to petitioner 1, they serve notice to petitioner number 2, who is not the owner of the land. So, to Siri so-and-so, Bugli village under Gumto circle, a complaint copy against you has been received from Circle Officer Gumtos regarding land dispute between you and Dili Tadab, which has endorsed me to resolve the matter at village level. Hence, you are requested to attend in the office undersigned on so-and-so and 11/5/24 at 7:30 a.m. Now, this is the letter issued by respondent 3, 4, and 5.
So this is 3, 4, and 5.
Yes. Respondent number. This is letter issued to the petitioner 2, not to 1.
They issue this notice in the capacity GB only.
GB only. So now I'll come to
GBs are empowered to decide the matter as per the Civil Court Act.
now
They issue this notice in the capacity of functioning while functioning as the judge of the judge.
no, sir. They
How they can be made as a
but
party?
there is arbitrary. That's why I made a party. They in the letter.
No.
Let's see here. Now come to page number 53. 53. The forwarding letter. The Apex Customary Court of 2, the Apex Customary Court of Arunachal Pradesh. In the name of all Arunachal Pradesh Government Welfare Association, Upper Dobam Bandardeva, District of Arunachal Pradesh. Subject forwarding of letter of Sri Dili Tadab. Dili Tadab is respondent number 2 here. GB Bogli 1, landowner / complainant versus Sri Devya Kozum, which is petitioner number 2 here. GB Bugli village, land seller, and Sri Nabam Tagam, land buyer. This was the endorsement letter. As cited, above on 29 April 24, the Circle Officer Gumto Circle District Papumpara has endorsed the undersigned Srimati so-and-so, GB Denka, Mr. so-and-so, GB Denka, to amicably solve the land dispute of Sri so-and-so. GB Bugli landowner and by Sri Devya Kozum, GB Bugli land seller, and Nabam Tagam land buyer. Subsequently, mail was fixed on 11/5/24 to attend a land dispute.
What is the procedure for receiving complaint and after complaint? What the CO has to do?
CO has
what is the provision provided for this? Under which provision?
What's here? The provision as part of provision. Say it's page 106. Page 106, Lordship. AFR. AFR,
Yes.
AFR page 106, 51, the power of the GB. The appointment of GB. The deputy commissioner shall appoint such person as he considers to be a member of the village authority to such village or village as may specify and may modify or cancel any such order, appointment, and may dismiss any. This is appointment of the
There is
GB.
appointment only.
And
What
Lordship
is the
here,
procedure?
now this was
Deciding
amended.
the case.
This one was amended in page number 114, Lordship.
One,
Amendment of section 10. 114 page number.
100.
114 page number. Annexer R series. This is the Arunachal Pradesh Civil Code Amendment Act
114.
114.
Yes.
This is the Arunachal Pradesh Civil Code Amendment Act 2022. Lordship. Amendment of section 10. Amendment of section 10. In the Arunachal Pradesh Civil Code Act 2021, Act number 4 of 2021, hereinafter called the Principal Act. In the section 10, after provision 3 to sub clause 3, the following subsection shall be inserted. Now standing
What is section 10 first?
section 10.
Yes.
Let me complete first here.
Hmm?
Now, pending anything contained in this act or any other law for the time being enforced. Enforced. Whenever a civil suit is instituted for trial by the village authority.
Where are you reading? Page
Page number 114.
114.
114. Close to. Now standing anything contained in this act or any other law for time being enforced. Whenever a civil suit is instituted for trial by a village authority, the concerned local administration.
Where are you reading? Page 114.
114, let's say.
Section?
Section 2, clause 4. This is amended one.
No, what I'm asking is where is the unamended one? Unamended section 10.
Amended. Let me find out. Registration of the civil code. Yes. This one. Section 10, posting of a district judge, additional district judge, civil judge, senior division, and civil
Where
judge.
are you reading?
Lots of, this is the first document I have announced. Jurisdiction of civil code.
You have not annexed it yet. You have not annexed.
It is not annexed here. Right?
We have the copy.
Yes, there is a copy.
Lots of. Lots of the Arunachal Pradesh Extraordinary Gazette, April 12, 2021. That is section 10. Posting of district judge, additional district judge, civil judge, senior division, and civil judge, junior division. No person other than a person belong to a grade 1 in so and so. No person other than a person belong to grade 2 so and so. No person other than a person belong to grade 3 in Arunachal Pradesh Judicial Service and eligible for posting of civil judge, or additional civil judge, junior division. Provided that the Deputy Commissioner under the Assam Frontier Administration Justice of 1941 in relation to the administration of justice prior to commencement of this act shall be deemed to be a court of district judge under this act in respect of appeal that lie from the customary court until such time such appeal are disposed of. The Court of Assistant Commissioner Administration Civil Judge under the Assam Frontier Mr. Justice Act 1945 prior to commencement of this act shall be deemed to be the Court of Judge Junior Division in respect of appeal that lie from the customary court until such time such appeal are disposed of. Court deemed to be established under
Okay, as
the
per this, that is why, as per the provision, in compliance of the provision, the CEO has endorsed the matter to the Gambura.
law.
So Gambura, that means is the functioning as the judge only, then how can you impede a judge?
Lordship, they have illegally, without reason, without hearing, they have transferred the case to the appeals customary Gambura precision.
Supposing the civil judge, junior division, senior division, or district judge pass such order, will you impede? Will you impede the
No.
judge? Then
No.
it's all the same. Isn't it?
Yes,
Even if they pass order, illegal order also, it has to be challenged before the higher court.
Lordship.
The order is to be challenged, isn't it?
Yes.
Not the judge. Then,
Then Lordship here, actually why we impleted them, because instead of taking up the case within their jurisdiction.
no, your first allegation is that the CEO should have and the Gampuras of which village you said?
Bugli village,
Mowgli
village,
village.
Bugli,
Spelling?
Bogli,
Okay, Bogle.
Bogli
Bogli.
village,
And then instead of Bogli, he has endorsed to the Gampuras of which village you said?
Denka village, Denka,
Denka. Bogli village is under which circle?
Gumto circle,
Gumto. And Denka is under?
Gumto circle,
Huh?
Gumto circle, same circle,
Same circle.
yes.
Then
Then they have not taken up the matter, they refer to the other, this is Bandar River circle, Apex, so-called Apex Customary Court of Arunachal Pradesh. So this is the issue also.
FX customary is an appellate court. Appellate customary court.
Appellate, yes, as per the this civil court act, Apex court, customary court is a recognized court, and this place first is there is two hierarchy logic. One is village level, then circle level. Circle level, within the circle level, there will be inter village customary court or Apex customary court.
Oh, who is this 6, 7, 8?
6,
8,
7,
they are also
6,
GB.
GB,
9
if-
also, all of them are GB. 10 also GB.
they are the so-called Apex customary court GB, that is from Bandar Deva. So I made a party.
You challenge the order. Why challenge GB?
Because if they have arbitrarily passed a decree
That is why I'm saying.
without my
If the district judge arbitrarily pass an order, will you challenge the district judge
logic.
or the order?
Right.
You challenge
No,
the order itself, not the judge. Isn't it? It's all the same. So what do you do?
so if then I may not to withdraw and I'll file a press
That will be
without
better.
taking the time.
You want to withdraw. So, yes. What do you say?
Sir, Lordship. Your Lordship, may kindly peruse the annexure 1, next by the petitioner, Your Lordship.
Annexure 1,
Yes, yes, annexure 1,
page,
page 53.
page,
Sorry, Your Lordship, not annexure 1.
40, annexure 1,
Yes, annexure F, Your Lordship, annexure F
F.
series, yes,
page,
page 48, Your Lordship. This is not legible, 48, Your Lordship. The type copy is 49, Your Lordship. Here, Your Lordship, Gambura Devya Kojum himself is a accused, Your Lordship, of illegally selling the
anyway,
plot
you
of
want to
land. Yes,
withdraw.
Your Lordship.
Just a minute, Anyway, you want to withdraw because it appears the petition, so many defects, it appears. So let him withdraw and file a fresh. challenge the
Lordship,
order, challenge the order,
Lordship.
and you are agreed by the first order passed by the CO. The CO has, if CO has not.
May I, Your Lordship, otherwise, Your Lordship, according to section 10, amended section 10, Your Lordship,
Hmm.
CO is only facilitating the procedure, Your Lordship.
So
Yes.
what he's saying is that facilitation is the duty of the CO is to endorse the proper authority, or proper gambras of the village,
Concern.
jurisdiction of village. So he has not endorsed the proper, because the cause of action or the property is at Mowgli,
Bogle, falls under Bogle.
Mowgli village, but then he has endorsed to some other
Place.
place,
Sir,
some other
Your
village.
Lordship, there is some element of threatening also, Your Lordship. It can be seen in the annexure. Annexure in the petition only, Your Lordship.
Hmm?
There is an accusation that the GB, this petitioner number 2, he is threatening the other GBs, Your Lordship, regarding this land dispute, Your Lordship. It is given in annexure 1.
GB is threatening the another GB.
Yes, GBs, Your Lordship, the other concerned
GB of
members of the whoever is concerned with the land.
You challenge the proper. Okay,
Lordship.
you challenge the proper order. Yes. Mr. Regum Nabam, National Council for the petitioner, who wants to withdraw this CRP with liberty to file affairs after making necessary correction in the petition. Okay, the prayer is allowed. This CRP is dismissed on withdrawn with liberty is prayed for. Okay.
Relevance.
Okay.
Yes.
Allowed this an application under section 483 of BNSS 2023, praying for the grant of bail of alleged accused person in connection with Itanagar PS case number 13/2025 under section 64 bracket 1/127 subclause 2.
The bail application.
Yes,
What is the allegation?
allegation is
Just where is the FIR?
FIR page number 18. May I, ma'am?
Yeah.
With due respect and humble submission, I have the honor to inform you that yesterday at around 11:30 PM, when I was coming from Itapur way to Papunala to the residence of my father-in-law.
Your bail was rejected by the trial court?
Yes,
Both.
my lord, at page number 40, annexure 4.
It was rejected recently only?
On the ground that, Your Honor, paragraph 6, page number 41.
Yeah.
On the ground that the investigation is almost completed, except few witnesses are remained to be examined and said
And considering the serious allegation made against the informant, made against the accused by the informant. So what is the new ground you have taken for filing bail application before this court?
Your Honor, already my statement has been recorded and I have been spending 36 days today.
No, that is the date. Those have been recorded. That is why I'm asking, what is the new ground you have taken for filing this bail application before this court?
My lord,
What is the new ground you have taken? Earlier also you have taken same ground that you are innocent. It was consensus, isn't it?
yes.
What is the new ground you have taken this time? This ground you have already taken earlier, that you are innocent.
Yes. No, Your Honor, my
And
only ground is that this paragraph 6 of the order, of learned session judge against this order. Almost everything is completed.
Have we completed there also almost, isn't it?
Yes. Only this is the ground I have come.
What is this ground?
On medical ground also.
Medical ground also,
Yes.
you have taken there in the, before the trial court.
Yes.
Court has found prima facie case against you. Okay, so
We'll be needing the CD, Your Lordship,
can copy.
scan copy.
Very. Mr.
P. Taggu.
P. Taggu. Land counsel for the petitioner. But also heard Ms. Chini, land counsel preparing of now, and additional PP for the state of PP. So, okay. Call for the scanned copy of the case diary. So, just a minute, this, before that, this is an application filed under section 483 of BNS S 2023. Praying for grant of bail to the who has been arrested in connection with the Itanagar women case number 13/2025 under section 64 within bracket 1/127 within bracket 2 of the BNS 2023. Call for the scanned copy of the case diary. This is matter next week,
On 19th, Your Lordship,
19 is
Monday.
Monday, okay.
Much of
Matter on Monday. No?
On 10/1/2025. It has been 120 days since his arrest.
121 days.
Yes, my lord. And my
Was the
lord,
charge sheet filed?
no, my lord.
Your Lordship, since this is under the NDPS and
Oh,
also
NDPS.
NDPS.
Yes, my lord, it is under NDPS Act. Default bail is 180 days.
Okay.
And my
Your
lord,
bail was rejected.
yes, bail was rejected on 21/2025 by special NDPS judge. And my lord, my lord, in arrest cum inspection memo, there nothing is given regarding the ground of arrest of the accused, which is completely violative of the section 47 of BNSS and article 22(1) of that.
No ground of arrest given.
My lord, may come to page number 5, my lord. Page number 5 of the petition.
There.
Yes, my lord. My lord, first of all, nothing has been recovered from the alleged accused
Okay. Anyway,
from his.
Anyway, what is the observation of the trial court there? Nothing was recovered.
Nothing was recovered and no ground was given for the arrest, which is completely illegal.
For the trial court. Whether the same plea that nothing was recovered from the alleged accused person, have you taken this ground?
Yes, my lord, I have taken this ground.
Which paragraph we find? Do we find? Which paragraph it has been reflected?
My lord may come to the order,
In the order of the-
come to the page number 13 annexure.
Yes, which paragraph?
My lord may come to the para 3.
Yes,
It is submitted by learned counsel that accused person are innocent and nowhere connected in the present case. It is submitted that nothing has been recovered from the possession of the accused. This ground was already taken. But it was
Actually, we do all
rejected
the
by this
practical-
common order, my lord.
But then the court found otherwise. The main accused and the presence and so have strong. Okay, anyway, we'll call for the scan copy.
No,
Still-
it's
Mr.
D name, my lord.
Plan counsel for the petitioner. Also hard mistake, huh?
And my lord,
Additional people. This is this is an application file under 483 of the BNSS 2023, praying for granting of bail to the accused Pravin Narzari, who has been arrested in connection with the Doimuk PS case number 0425 under section 20 within bracket C, stroke 27, capital A, stroke 29 of the NDPS Act 1985. So, for the second copy of the case title. List is matter.
on 21st, your lordship.
Hmm?
21st,
21st
Yes.
is,
the Wednesday, your lordship.
okay, 21st. This is of which
This is-
place?
This from Collector. Township.
Kalakkan.
Yes.
Okay. 21st. Okay.
much advised.
Yes.
May I please, lordship?
Yes.
Lordship, this is a joint criminal petition for quashing of FIR, which was registered.
What is the allegation?
Allegation, lordship,
It's a joint petition.
joint petition. Petition number 1 is the complainant who lost the FIR.
Okay.
Just after 15 days, he is clearing the juvenility of the Alice involvement person. He has been, the dispute has been settled between the parties, lordship. But since the
Okay.
FIR has already been registered, because of this, the both jointly filed this application.
The accused is minor.
Minor. Therefore, the petitioner number 2, who is the father,
We call for the.
Scan copy of the case.
Scan copy of the
Case diary.
office. The matter is still under investigation.
yes,
Okay. Okay, hard Mr. K. Lawler. Land counsel for the. petitioner. Also hard Ms. Lakshmi, H. Lakshmi, land in additional DP for the state of AP. This is joint petition file, joint application file under section
528 of
528 of the
BNSS.
BNSS 2023 for compounding the non-compoundable offenses. Yeah, for setting aside,
Yeah.
setting aside of the
FIR.
FIR dated. FIR setting aside will be very difficult. Maybe
33.
30/3/2025. Register against
Minor accused person.
minor accused. Just a minute. Just leave that. For crossing of the, okay, FIR dated so and so, registered. And registered is Itanagar one, registered against a minor accused. Being the Itanagar woman PS case number 1125 under section 77/79 of ENS grade with section 66 within bracket capital P bracket close, stroke 67, stroke 67A, capital A of IT student. Whole book. The scanned copy of the case diary. The case of which place?
Itanagar government place.
List is matter. After. List is matter when?
23rd, Lordship.
23rd. 23rd. Okay.
Deeply obliged.
Yes, Mason. This is second appeal, my lord, regular second appeal, my lord. I'm impugning the, my lord, order dated 9/3/2025 by the appellate court, my lord. And judgment in degree dated 24/6/2024, my lord. What happened in this case, brief issue in this case, my lord. I filed a title suit, my lord. I filed a title suit, my lord, claiming a land over title, my lord. Before? Now, dear, my lord, before the civil judge junior division, my lord. Okay. Civil judge. Now, in this case, my lord, responding were, my lord, Secretary Lane Management, my lord, Director Lane Management, Deputy Commissioner, my lord. Before the trial court? Trial court, my lord. Okay. Dependent, my lord. Now, those state dependent, my lord. No private respondent? No, no private respondent, my lord. Okay. Now, those state respondent, my lord, did not contest the case, my lord, even after notice, my lord. Only the case by the director of police, my lord. Police department contest the case, my lord. The other department, the lane department, my lord. Lane management did not contest the case, my lord. So I'm indicating this, my lord, to extent of my pleading against the state lane department, my lord. If that was not contested, that deemed to be admitted, my lord. Deemed to be? Admitted, my lord, as they did it mainly against the state, my lord. State, my lord. State means which department? Lane department, my lord. Ultimately, in our the lane is being taken care by the state lane department, my lord. Okay, then why you have included this commandant? They now BGP. Now, in the suit, my lord, this respondent dependent on 456, my lord. That is the police department, my lord. Contest the case, my lord, saying that, my lord, that was been allotted by me, allotted to them by the lane department, my lord. Yes, yes. But peculiar thing, my lord, note, my lord, the lane department, my lord, did not contest my plea, my lord. The only contention is by the police department, my lord. That was department had the allotment order. Allotment order by the land department. Then now in the trial court, my lord, evidence lead, my lord. Now trial court, my lord. See, mainly dismiss my suit on the background that, my lord, I serve, my lord, Section 80 CPC notice, my lord, only to the Deputy Commissioner, my lord. Only to the Deputy Commissioner, my lord, not to the not to other department. Okay, then that is the issue part in my again, my lord. Now, on some evidence also, my lord, he has discussed the issue, my lord, and on the but my evidence, my lord. Though that has been discussed, my lord. The trial court has dismissed. On merit also. Oh, that's on merit also, my lord. Now thereafter I approached the appellate court. Now appellate court raise a issue, my lord. Kindly have a look at appellate court judgment, my lord. Will find as, my lord. Page number 55, my lord. This is 49, my lord. Page number 55, my lord. Start from 49. 49, my lord. But the ultimate judgment that region that influenced the my lord, learned appellate court, my lord, will find it, page number 55 para 16, my lord, start from my lord. Page number 55. Para 16. Para 16, my lord. Yes. Down below. 7(1)(b) of the Registration Act provided a sale deed of an immobile property is a compulsory registrable documents. But in the present case, not to speak of any documents or registration of immobile property, the plaintiff is taking the plea of parcel of land in excess of matter, and there is no registered sale deed to prove such parcel of sale by the plaintiff. It is a principle of law that no person can be claimed ownership over an immobile property by an unregistered sale deed. As the plaintiff has claimed the owner of the suit land, who is allegedly purchased from Gambura Tantal, it is a burden of plaintiff proof that he has bought from Tana Kuli by way of a registered sale deed as provided under the law. In present case, now, if my lord allow me to analyze this particular para, my lord, in my humble understanding, my lord, what the appellate court conclude that if I have a claim over any land, my lord, that need to be proved by only evidentiary documents, my lord. Which I, my lord, humbly believe, my lord, that it be against the law, my lord. My understanding of law, my lord.
Let us read again the
Section 17(1)(b) of the Registration Act provided a sale deed of immobile property is a compulsory registered document, my lord. That is undisputed, my lord. But in the present case, not to speak of any documents or registration of immobile property, the plaintiff is taking the parcel plea of the land in excess of Medun, and there is no registered sale deed to prove such parcel of sale sued by the plaintiff. It is a principle of law that no person can claim ownership over an immobile property by virtue of unregistered sale deed, my lord. Now, if my lord will go through the record, my lord, in whole my case, my lord, I never exhibit any sale deed, my lord. Now, if this is to be taken, my lord, the land, according to landed appellate court, my lord, any, my lord, claim of land, my lord, title, my lord, need to be proved by the documentary evidence, my lord, my lord. Whereas in terms of my understanding of law, my lord, as per the India evidence, my lord, the title, my lord, can be proved by the oral evidence also, my lord. It's not necessary, my lord, that all the claim, my lord, can only be proved by the documentary evidence, my lord. Therefore, my lord, in this second appeal, my lord, the past law of question, my lord, the substantial question of law, my lord, that I am raising, my lord, in this case, my lord, whether, my lord, title, my lord, can only be proved by the documentary evidence, my lord. Regarding this, what is a substantial question raised? My lord, regarding this. Regarding, my lord, if I understand this particular part correctly, my lord, the learned appellate court in hold that normally, my lord, any claim, my lord, of the title need to be proved by the evident. Regarding this, where what is your substantial question? Substantial question of law, my lord. I have indicate, my lord, at my lord, page number 35, my lord, starting from page number 35, my lord. Page number 36. 5, my lord, I have part page number 36, my lord. 5, I have read the issue that the issue that the section 17(1)(b) of the registration can be interpreted in such a way that it is only through registration that a claim of title can be if we go into this section 17(b), my lord, this only provides, my lord, that if, my lord, if say that, my lord, is unregistered, my lord, that cannot be lead as evidence in the court, my lord. That is the bar, my lord, under this 17(1)(b), my lord. 17(1)(b), my lord, only bar, my lord, exhibition of sale deed, my lord, as a evidence, my lord. If that is not registered, my lord, it never say, my lord, 17(1) we never say, my lord, all the title, my lord, need to be proved by the documentary evidence only, my lord. Now, another, my lord, substantial question of law, my lord, that I am raising in this second appeal, my lord. Another, before that, my lord, have a kindly look at page number 54, my lord. Yes, whether you have received, Mr. Tapi? Yes. You received the copy?
Yes, sir.
Okay. My lord, representing all the respondents. Okay. My lord, before coming to second substantive question of law, my lord will have a kindly look at page number 54 of the page 54, my lord. Page number 54, my lord. Last para, my lord. Para 14, my lord. Para 14, my lord. May I read this, my lord? Para 14. Section 95 of Arunachal Pradesh Land Settlement and Record Act 2000 provide that no suit or proceeding shall, unless otherwise expressly provide for the act or in any law for time being imposed, lie or be instituted in any civil court with respect to any matter arising under any provision of the said act. Provided if a dispute between party, a question of law, question of title is involved, a civil suit may be for the execution of such question, provide further that the civil court shall have jurisdiction to decide any dispute to which the government is not a party regarding any right or title, which is record in a record of right. In present case, my lord, in present case, the plaintiff has claimed for title and ownership over the suit land and instead of ownership being independent, there is a reasonable doubt as to whether civil court has a jurisdiction to such suit, as provided under the act, said act. If there is any dispute regarding the allotment of or non-allotment of land, the appropriate revenue authority or appropriate shall have full jurisdiction to decide such issue, my lord. Now, if this is to interpret it, my lord, this Planet Affiliate Court, my lord, was I believe that, my lord, due to section 94, my lord, or 95 of the this Arunachal Pradesh Land Settlement Record, my lord, bar, my lord, civil court to, my lord, proceed with the trial, my lord. Now, therefore, my lord, in substantive question of law, my lord, I have also raised this, my lord, that the section 95 of the Arunachal Pradesh absolutely bar the civil court for entertaining a suit, even when there is a serious dispute of law, serious dispute of title over the land, my lord. This is the second substantive question of law, my lord, I am raising in this case, my lord. Now, third, my lord, though in regard to section 80, my lord, past appellate court, my lord, held that particular, my lord, conclusion of the trial court, my lord, that it is necessary to, my lord, issue notice under section 80 to all the dependent, my lord. The appellate court viewed that is not necessary, my lord, wrong on the part of the trial court, my lord. But then as I am also impugning the trial court judgment also, my lord. Therefore, the second substantive question of law, my lord, in this case would be, my lord, under section 80 CPC, 1 CPC, it is mandatory to issue notice to each dependent, my lord, in addition to the notice to the deputy commissioner before institute of title against government in substantive question of law, my lord. Now, in addition to that, my lord, I humbly believe, my lord, if there was, my lord, suppose, my lord, even in fake, my lord, suppose evidence was not considered, my lord, by the both trial court and appellate court, my lord, that would be surely a substantive question of law, my lord, need to be looked into by the second appellate court, my lord. In this case, my lord, we read the judgment, my lord. our evidence, my lord, oral evidence, my lord, where, my lord, negate by the both trial court and appellate court, my lord, with any reason, my lord. So they have discussed, my lord, but they did not negate reason where, my lord, this evidence, my lord, cannot be if discussed and not given relief.
Reason.
That's discretion.
Discuss only, my lord, discuss, but
Discretion.
no, my lord. Evidence,
Decision on discretion.
evidence needs to be discussed, my lord.
Hmm.
A discussion, my lord, if we negating it, my lord, there should be some reason for to negate the those evidence, my lord. Until without any reason, my lord, how, my lord, the material on record, my lord, the material on, evidence on record can be, my lord, not considered, my lord. Only discussion will not do, my lord. Now, in terms of merit, basically, my lord, what contention or dependent were, my lord, the lane, my lord, was within the earlier allotted lane of their police department, my lord. Now, on the record, my lord, there were evidence, my lord, a survey report, my lord, by the lane department, joint inspection by the survey report, wherein the dependent was also party, my lord, saying that, my lord, those lane, my lord, was not allotted to any government, my lord, or does not belong to, my lord, any party, my lord, and fit for allotment to the police department, my lord. Those are the record, my lord, material on record, my lord. Now, there should be a reason, my lord, to negate it, my lord. And another, my lord, material on record, my lord, that favor my case, my lord. I would not say, my lord, that I prove the case, my lord, beyond reasonable doubt, my lord. But in terms of proof of preponderance, my lord, there was a document, my lord, that by the deputy commissioner, my lord, giving a compensation, my lord, while to me, my lord, while acquisition of the land, my lord. These were all the official material of the state dependent, my lord. Now, all those documents, my lord, were negate without any reason, my lord. So, at this stage, my lord, my humble submission, my lord, will follow the record, my lord. And notice, my lord, and as, my lord, during the pendency of appeal, my lord, the judgment, my lord, of the trial court, my lord, where stay by the appellate court, my lord will give me a interim relief, my lord. Stay in this judgment, my lord.
If you see the judgment passed by the appellate court, he has dismissed the appeal on merit as well as on the technicality. Yes. Once it has been held, it has been dismissed on merit. Then there's no issue of the substantial questions from law. Even if technicality is kept aside also, then on merit it has been dismissed also. Even if on technicality, if it's upheld, but on merit you will be dismissed again also. Among the grounds, if one ground is sufficient to dismiss the lawsuit for appeal loss, it has been done in this case loss. If lawsuit see the order, detailed discussion has been done by the learned appellate court. Kindly see the page 52 lawsuit. 51 lawsuit. 51 lawsuit. Yes. Yes, I'll read from the bottom. There is paragraph 6 lawsuit. It's a part of the impugned order only. The order passed by the appellate court. Whereas the plea of the defense is still denied. The defendant number 1 to 4 remain absent despite of service of notice, and accordingly should proceed the expert against so and so as per order so and so. The defendant number 5 and 6 in their written statement has averred that there is no course of actions for filing the suit. It is evident then that the suit land is not the ancestral property in 1988 by number so and so dated 3 to 1989 by the chief project officer, government of Andhra Pradesh. The plot of land claimed by the plaintiff falls within the allotted land of first APPN. Defendant have denied that formation cutting was allotted to Sri Tanakuli as the owner of the land. There is no documents to prove that Sri Tanakuli was awarded the said work as contractor or owner of the suit land. The departmental inquiry, plaintiff had stated that he occupied the suit land since 1994, but as per service record, plaintiff was permanent inhabitant of Tomlang village, Sangram of then Lower Subansiri district, and at the relevant point of time, the plaintiff was only 19 years old and was living in Sangram, which is far from the suit land. Since he was living far from the suit land as was young at that point of time, so it is improbable that he was mature enough or in position to purchase any property in an area that was far from his place of residence. The arraignment made by the plaintiff having purchased the suit land in 19 is therefore false and concocted. It is further pleaded by the so and so that the plaintiff is in reply to notice served by the department categorical that he occupied the suit land in the year 1994, which proves false the arraignment of the plaintiff that he purchased the suit land from Tanakuli in the year 1987. The plaintiff was appointed as constable in first arraignment on 30/4/1988 and underwent training at PTC Bandodra till 12/4/1998 and posted at Bikoi Teju on 25/11/1990 and transferred from there first APPN Itanagar on 16/5/1992. Hence, the statement that the plaintiff was residing at Chimpu since 1998 and the planted plants and trees is false and concocted. This is the lordship on our part, and lordship kindly say page 55. On merit lordship, the paragraph 15 lordship, the issue number 2. The issue number 2 in the suit is whether the plaintiff purchased the suit land from Sri Tanakuli of Chimpu village in 1998 in exchange of 1 mitun, and the same was in physical possession of the plaintiff for about 22 years since 1994 to 17/8/2015. That's the issue. In the present suit, the plaintiff has claimed for a decree and judgment that the scheduled suit land is a private land of the plaintiff, and the plaintiff has absolute title and ownership over the suit land. The And another plea is that in the year 1994, the plaintiff has cleared and possessed the suit land till filing of the suit land. Sections 101 of the Evidence Act provides that whoever desires any court to give judgment as to any legal rights or liability dependent on the existence of facts, which he asserts, must prove that those facts exist. In present case, the plaintiff has taken the plea. He purchased the land from Tanakuli in exchange of a mitun, and to prove such plea, he has disposed oral evidence as well as said Tanakuli has examined PW3. Said PW3, namely Tanakuli has disposed of that he has sold the suit land to the plaintiff Taitache in exchange of 1 mitun. However, the said Tanakuli could not prove his ownership over the suit land for transferring the same. It has been held in merit because this is for the appellant or the plaintiff to prove his case before the child court that he has purchased this land And before going to the next, because in next page, no, say paragraph 18, 19, there also the learned court below, the appellate court, decided against the petitioner on merit only. So for registrations of Registration Act is concerned, no, say, that is an additional observation. No? And so far 80 CPC is concerned, the London Appellate Court has held that okay, London 80 is okay, no issue. The last paragraph, page 57, paragraph 21. Paragraph 21, what the London Appellate Court says, in view of the discussion regarding the material available on record and as the plaintiff has failed to prove the right or ownership over the suit land, the plaintiff is not entitled to get any degree in his favor. The trial court has dismissed the suit, though the ground of rejecting the relief is different. But in any view of the matter, the plaintiff is not entitled to get any relief. In view of the above, though the finding of issue number 1 is considered on the ground of no summon, which is not according to 80 CPC, but there is no merit. But there is no merit on the suit of the plaintiff for getting any degree in favor. 80 also the appellate court, okay, 80 is wrong, that part is wrong. But on merit, you have not proved your case. That is the mind of the first appellate court. Now, next is we see this document is was the part of the written statement. Here the written statement has been annexed, but the document has not been annexed by the present appellant. If you want to see this is the reply, because departmental procedure, this is the case lawsuit where the employee has occupied his own employer's plot, land, and departmental proceeding was drawn against him twice. This is the reply filed by the appellant. Kindly see the article, what he has replied. Reply to the memorandum of articles. Article number 1, kindly see, regarding the land allotment. I am not denying that the first IMN has not have a land allotment. But regarding the question of selling of tree, I am fully denying that I am not sold any trees where the land is land I occupied. Rather, I was also inquiring of who has cut my tree from my occupied land. But on my inquiry, I did not found who has cut the tree. Only I presume that road construction party has taken the tree, therefore so and so. Here, the petitioner has admitted that the land is allotted to the APPBN. Then on next, also, if you want to turn next page, I'll read from the second line. I have doing garden there by planting bamboo and other domestic things. Now it also learned that your authority concerned had taken compensation from NH 52 road construction company, which your authority is no right to claim the land, as the jurisdictions of land is falls under the road construction company. Therefore, I am now fighting with the land department, which the land in question belongs to me, because now land is falls under the highway authority or land revenue department. Furthermore, it is also seen as per the map, now land is in dispute falls under the highway, hence the land is not in possession of APPBN. Here, what he is submitting is that petitioner took during the department proceeding. And the down below, the last that part, I am claiming that the plot of land from government for allotment. The last paragraph, Your Honor, just article above the article 111. I am claiming that plot of land from government for allotment. Therefore, if after verifications by the government, if says no, then government will decide the land belongs to whom. It's my land, the government will decide, and I'm afraid the land allotment. And then kindly see, in entire lawsuit of department proceeding, he has filed written statement and representation to the department order. In all lawsuit, he has taken.
I'm sorry, my
step
lord, about the department, I will title suit, my lord, department inquiry, my lord. If I allow, my lord, I'll inform this command about department that has already interfered this division place of this honorable court, my lord. Now, how, my lord, the whole those
No,
issues
no,
can be
facts
argued in
but-
this case, my lord. Let us argue on the record of the trial court, the affiliate court, my lord. How this made from now where, my lord, he is bringing the record and arguing the matter, my lord. Let be fair enough, my lord. Let me argue on the material before the trial court in the appellate court, my lord. About the disciplinary proceeding, my lord, that has been already interfered by the division bench of this honorable court, my lord.
Here's the, he wanted to show that the case was decided on merit, on appreciation of that.
Not, my lord. Then, my lord, I will insert it, my lord. How decision made?
Then you just, then in that case, probably it will take longer time, so we'll issue notice. Or we'll hear
Yes.
on the
Substantial
question of law.
That can be done, because why this is,
It might
this
take longer
objection, why this objection is not tenable? In very beginning, I have submitted, this document was a part of the lawsuit, the written
Right.
statement. He has annexed the written statement, not the documents. It should have been the part of this appeal. On that count, it can
I'm
be.
sorry, my lord, before making such argument, the landed council need to note that any document in the written statement does not eventually value, my lord. They need to be exhibit, my lord.
And, okay, then,
Therefore, my lord will kindly have it 15, my lord. Only I am saying, my lord, the trial court in the appellate court, my lord, dismiss my case on merit basically by saying that, my lord, it need to prove by the evidentiary documents, my lord. Therefore, my lord, my
Because
past and substantial question of law in this case would be, my lord, whether the title, my lord, can only be proved by the document evidence, my lord, whether that cannot be proved by the oral evidence, my lord. If, my lord, allow me to read the para 15 also, my lord, this also what the appellate court held, my lord. Appellate court held, my lord, though, my lord, the person whom I passes the lane, my lord, appear and depose, my lord, yes, I sell it, my lord. But what that appellate court is, there is no document evidence, my lord. That cannot be accepted, my lord. It is not the law, my lord. I humbly believe, my lord, the plea, my lord, can always be proved by the oral evidence also, my lord. It not necessary, my lord, all the pleading, my lord, all the issue, my lord, can only be proved by the documentary evidence, my lord. Particularly this section 17B, my lord, of the registration act does not provide so, my lord. If my,
so we'll have hearing on the substantial question of law, then.
Just one important thing. Can you take up the documents which I have submitted? Nothing will find on the top, the page 12. Evidence. So I do not occupy the land towards so and so. Why are you claiming the land which is other side of the road? Something has been left. I have been cultivating vegetable, etc. If I do not claim or occupy it, others will claim. Many are trying to occupy it. Because while cutting the road, some portion has left to the other side, northern side. So he has occupied. This is the part of the written statement. Anyway, you know, may issue notice.
Had Mr. Leasing permit. Land council for the appellant. I have also had Mr. Tapin. In a government. By this application, the appellant challenge. Appellant is selling the order. 29/3/2025, passed by the Ghana District Judge UP of Bharat, Arunachal Pradesh, that is appeal number 5/2024, whereby the title appeal filed by the appellant has been dismissed. So, issue notice. Since Mr. Tapin has accepted my notice on behalf of all the respondents. Notice is made returnable by, which day? 3 weeks. 3 weeks, okay. Returnable by 3 weeks. Least this matter again.
Records can be called.
Okay. Records for, okay, call for the records. Then.
Interim, I have objection.
The, on the next stage. On the next stage. They should release this matter again after 3 weeks for hearing on the substantial question of law involved in this case. I have interim period. Otherwise, my lord will kindly appreciate, my lord, during the affiliate proceeding before the affiliate court, my lord, the judgment of the trial court was on stay, my lord, what stay, my lord, that I have enclosed the document, my lord. Now, if during this second appellate court, my lord, if that is not stay, my lord, my case will be in practice, my lord. No. The balance of convenience is in my favor. That was in the stay by the affiliate court during the whole proceeding, my lord. I have enclosed the document, my lord. My lord will kindly have a look at page 366, my lord. Last page, my lord.
Yes, the Supreme. No, Honorable Supreme Court.
366, my lord. Where is your prayer? My prayer, my lord, will find at page number 44, my lord. Interim prayer, my lord. Ultimately, my lord will during the for my interim, my lord will not get into the merit of the case, my lord. Only balance of convenience, my lord. Now, balance is this trial court order, my lord. Stay during the appellate court, my lord. Now, balance of convenience is in my favor, my lord. Only for returnable that, my lord will kindly stay this, my lord. I have any. The lane is allotted lane, and then who is under occupation at the moment? It must be the respondent. In my occupation, my lord, that it undisputed, my lord. That's why, my lord, with my humble submission, my lord, I have my interim prayer, my lord. While considering my interim prayer, my lord will look into the balance of convenience only, my lord. If my lord, no stay is granted, my lord. If my lord, this particular suit of suit lane, my lord. Judgment declared 24/6/2024. The judgment was stayed during the before the appellate court, my lord. Page number 366, my lord. Now, what is otherwise the
Lordship,
question of the lane?
yes,
it's formulated, it's very difficult. Prima facie it appears that because it was decided on merit or on appreciation of the evidence.
And can you see the
Okay,
paragraph
then
19 and 20 laws?
my lord will fix the, give me a fixed matter, my lord. Next date, my lord,
19 and 20.
after framing of substantial question of law, my lord, my interim will be considered, my lord. My lord will, as my lord is not formulating the substantial question of law today, my lord. My lord will give me fixed date, my lord.
And paragraph 20C laws. It's very clear laws. Interim cannot be granted.
If we go by that judgment, my lord, the appropriate, my lord, day, my lord, to formulate a substantial question of law is today itself, my lord.
This judgment of this year only.
Yes, ma'am. I have no dispute, my lord. In there, if my lord, my senior counsel is relying on those judgment, the appropriate would be, my lord, will frame the substantial question of law today, my lord.
Now, after hearing on the question of, on substantial question of law, we'll also hear your interim prayer.
Okay,
Let
my
us
lord.
see.
Then my lord will give me
makes out the
fixed date.
makes out the case that there's a
Then-
subsequent question of law. Then only
then
we can
Yes,
enter
ma'am.
into this issue.
Okay,
Then my lord will give a fixed date, my lord. Fixed date, kindly, my lord.
fixed date.
Fixed date, my lord.
After 3 weeks, he is asking
No, no,
for fixed date.
no, I'm not talking 3 weeks, my lord.
No. Honorable court has given 3 weeks time. Then this date can be given after 3 weeks. No issue.
No, my lord. That is, my lord, that is really prejudice me, my lord. My lord, I consider extended, my lord, only substantial question after framing of substantial question of law, my lord, that can be stay, my lord. Now, if there is a normally substantial question of law, my lord, is framed on the admission, is today, my lord.
Records has been called.
A record call, my lord.
Records has to come and then only it is can be formulated.
Next date is fixed for hearing on the substantial question of
Yeah,
law. In that case, your interim prayer also will be considered.
And my lord will kindly observe, my lord, my interim, my lord, will be considered on that day
Okay.
also, my lord.
On which date the interim prayer shall also be considered.
Yes.
My lord will kindly fix the matter of my lord, 29, my lord. 29, my lord. The record is available in the appellate court itself, my lord.
Is it okay, 29?
Yeah, it can be fixed.
Okay.
Otherwise, it can be
June.
fixed on 3rd June.
Second, 3rd June.
3rd June.
Oh, 3rd June. Okay.
Obligation.
Yes.
Yes, Lordship. Lordship, this is for passing of the criminal proceeding against the petitioner number 1. That is GR number 01 2024. That is pending trial in the court of CGM 0. This petition is for passing of the criminal proceeding against the petitioner number 1, which is pending trial in the court of CGM 0. The case, the applicant, petition number 1 is the husband, and the petition number 2 is the wife. Both are
Husband and wife.
yes, husband and wife. The facts in this case, Your Lordship, is that on 31/12/2023, it was the celebration of the wedding night. Both the petitioners, the husband and the wife, they were celebrating 31st night in the house of the mother-in-law of the husband. So,
Who the petitioner is? Petitioner number 1 is husband.
yes, and 2 is the wife.
2 is wife.
Yes.
Just a minute. What is the allegation? Is this informant?
It is the brother of the petition, the brother of the petition
Brother
number
is
two.
not the party.
Because he is not the my submission, your lordship, in that case, since the victim is since the victim has approached,
Maybe, but then he is the person who has lodged FIR.
FIR can be filed by any person, your lordship.
Hmm?
FIR can be filed by any person.
Yes,
Yes,
but that has to be made as a party.
not necessary, your lordship.
Where?
Unless
Can you
they are the victim. Now he is not the victim here. Victim is the petition number one.
can you show can you show the court how the informant is not a necessary party?
Because your lordship,
Under what provision?
as
Because he is the person who has lodged.
that is true. But as of the provision, right now, I don't have any specific provision to cite, your lordship. But my understanding to that aspect is that since he is not a victim in the case, and no, since he is in the matter, so his party in the case is not essential.
Supposing the informant is, or the victim is a minor and he has lodged, then
In that case, that is
in
essential.
that case, he is not a victim.
Yes,
But here is also,
but here your lordship, the petition number two is of 28 years. Who is
can it be without knowledge of the informant?
Lordship, here, Lordship, as per the Lordship, this case law, Lordship, Lakshmi Nine and all Lordship, where the victim and this Lordship, accused Lordship, if they are in husband and wife, if they have settled themselves.
Without informing the other side, without informing the person who has got information.
Lordship, because as per this, Lordship, they are
because at the time she was in
because this injury, Lordship, the 326 is invoked here, Lordship, this is a grievous injury. But
Yeah.
Lordship, for that, Lordship already charged it and now it's a stage of CC stage. But Lordship, on the Lordship, first occasion, Lordship, the Honorable Court has stayed the proceeding, that considering that the both the parties are husband and wife, and they have, as per the agreement, they have mutually settled their dispute and living peacefully together. On that basis, that is state Lordship on last occasion.
So next there is fixed for CC.
Yes, Lordship.
What is your submission?
Lordship, my submission that Lordship, as per the Lordship, Supreme Court, I also Lordship, they have considered Lordship, if the husband and wife have mutually settled and living peacefully, then that can be Lordship. Was if they have not living Lordship peacefully together, Lordship, then it can be a different story. But here,
So
Lordship,
they
as per
stated that
agreement,
they are living.
yes,
Huh?
Lordship,
Okay, living as wife and husband.
yes, Lordship.
Now,
As per their agreement, Lordship.
okay. When this case was stayed, the
20/01/25.
Where is the agreement?
That is on page number 38. Annex 4.
In the third paragraph, lawsuit, whereas the accused person and the victim, being husband and wife, are living together peacefully, they want to close the case to maintain peace in the family. Upon this consideration that earlier that Honorable Court had stayed the proceeding.
Okay, then there is no objection to pass order.
Yes, Lordship.
Mr.
K Taja. K Taja. Kago Taja.
This is, I think,
14.
40. K Taja, Kago Taja, land counsel for the petitioner. I've also heard Mr. Hage, land addition of people. I'll pass order. Huh?
Yes, sir.
Okay.
I'd like to.
Hmm. Yes.
Did you-
Yes.
Steps were taken upon respondent number 2 on 3rd of April last.
Steps taken? Yes.
My lord, I would like to 25. Successive bail application has to be filed before the same court who has rejected the earlier one. So
Okay.
here in this case,
It was really.
it was
earlier.
rejected on 7/2/2025 by Justice Atta.
Okay.
So it has to be placed before him, Your Lordship, in light of the clause 3 of notification 27.
Then to be listed before.
Before the appropriate bench, yes, Your Lordship. In 3, clause 3, Your Lordship. In case of subsequent bail
Yes.
application paper, the bail application paper after rejection of earlier, such bail shall only be listed before the same honorable bench who had earlier decided.
In view of the notification number 27 dated 13 May 2025, let this matter be listed before the appropriate bench. Okay. Over.
Obliged, Your Lordship.
So this is a bail application filed by the father of the accused persons, praying for releasing of the accused person who has been arrested on 27/7/2024. Your Honor, in this case, the case has already been charge sheeted. The trial is proceeded. I, doctor, and 2 more witnesses have already been examined. But the accused was on 2 occasions has jumped out the bail. So subsequently,
This is for?
This is bail, Lordship.
bail, Your Honor.
This is for bail.
Yes.
You are for accused.
Yes, yes.
Okay. Accused jump bail.
For
On 2 occasions.
2 occasions.
Okay.
Then,
I thought this is for the rejection of bail. Yes. Sir.
then subsequently, because on 17/12, just wait, on 11/5/2025, I have filed a bail application before Lanet Session Judge.
Hmm.
It was stated kindly see the
So when you pay a file bail application,
11-3.
when it was rejected,
rejected on the ground that on 2 occasions I have jumped out the bail conditions.
okay, because of that,
Yes, because of that only.
okay.
And also saying
Why
that
you have come this time?
because, my lord, after being arrested,
Hmm.
it has now become, since I was arrested on 27/7/2024.
27?
27/7/2024.
Okay, so the case, what is the status of case? You said
I or doctor, 2 more witnesses already been examined.
examined.
Yes.
Now I think you need to be there inside,
You-
because you have
I-
already jumped on 2 occasions, so this trial need to be complete
And my lord, also taking
while
into
keeping him
account,
inside the custody only. It appears.
my lord, kindly see, page number 28.
Hmm.
Page number-
Whether, while rejecting the bail,
Page
the
number
Islamic
20.
court has also made an observation that he have already jumped bail on 2 occasions.
And also made an
What is
observation.
in page 28?
Page number 28, since 17/7/2018 to 30/12/2024, the case was adjourned
Hmm.
because of some reasons. Reasons in a sense, because the court was not in the sessions,
Hmm.
and due to paucity of time, the case could not be taken up. And again,
17/7/2018.
17/7/2018 to 30/12/2024. Now, and even after being arrested,
No,
no,
where is that order?
Lordship, in the
27/7/2024.
uh,
17.
plus 23/7/24.
Hmm?
23/7/24. It is reflected in the page 41 of the order dated 11/3/25.
yes, yes.
Page 41.
Yes, Lordship.
This is 25, 11/3/25.
Yes.
Yes. Here in this order, it is reflected that he was last arrested on 23/7/24.
23/7/24. Okay.
Before that, he was granted bail on 21/9/2020, and 2020 to 2024, he was on bail. But again, because of his jumped over the bail condition, he was again rearrested on 23/7/2024.
So, my lord, after being arrested on 23/7/2024, I have been in a custody, and since then, no prosecution witnesses.
Bail also you see only paid for discharge. And the previous okay, since 23/7.
Because I was arrested in another Kevin PS case. Another Kevin PS case. So,
Where, in the same station?
yes, 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 Kevin PS case. Then I was produced before the learned session judge. Thereafter, I was arrested. Since the case was pending before the learned session.
Now you are in
judge.
2 cases. You are inside
That- that-
in 2 cases.
That another Kevin PS case, because the case has not been charge sheeted.
But then in that case also you are inside. As per the order. You are shown.
In that case, bail was granted.
Okay, then.
Yes.
When bail granted.
Yes, in that case.
Okay.
So now, Your Honor, because after being arrested,
it has now become almost more than 9 months. No prosecution witnesses has been examined till now. Apart from that, IO, doctor, and 2 more witnesses has examined. And PW1 has been to turn 18. Till date, she has not been turned up.
Who, the victim?
Yes, yes, yes. So
What is the offense alleged against you?
offense is below section
376.
366, 376 2H and 506.
Oh.
So therefore, I undertake before this honorable court to appear each and every hearing without fail. And I am a resident of the Kimin village, Kimin, and there is no chances of hampering, tampering of the evidences, witnesses.
The judge, the trial court has also observed that trial could not proceed for 7 minutes. It was further.
Yes. Lord, I would humbly say that it was wrong observation made by the learned court below. Since 17/8/2018, no trial has been proceeded due to paucity of time. The court was not in the sessions due to some reasons also. But since 2018,
How many witnesses remain, you said?
uh,
How many witnesses are yet to be examined? Two.
yes, it's 2 witnesses left.
Then what is the evidence? Have you gone from, is there any prima facie case against accused?
Lordship, here Lordship, that the PW called for Lordship for in the trial
But
Lordship.
Victim has not been examined.
Victim Lordship, I think it's not been examined. It's examined. Oh, it's not been examined yet, Lordship.
Then whether there is 506 also against you, apart from 376.
My lord, at this answer because after being arrested, it has now been almost 9 months without trial being conducted. Since PW1 has not been turned up.
No, we'll give direction then.
So therefore, for the interest of justice, I undertake it, I will not jump out of bail conditions. And I am the permanent resident of Kimin, and there is no chances of hampering and tampering.
Recording deposition, okay, that's clear. Have you gone to deposition? Is there any material against the accused?
Lordship, as per the Lordship, this all the records I have gone to the, he was previously on bail, Lordship.
No, that is.
Maybe, yes, Lordship. So Lordship,
What I'm saying,
yes, Lordship.
my question is, as per the victim and who else is to be examined now? Whether doctor already examined?
Yes, Dr. I.
Already examined?
Yes, and 2 more witnesses were examined. So keeping me inside the custody is of no use, my lord.
No, the delay probably has also been caused due to non-appearance of the defense counsel also.
Yes.
At the time of commission of offense, she was pregnant. You need to be examined.
My lord.
The victim need to be examined before.
What is your honor, and with any terms and conditions that may be imposed by some, because FIR as already has been perused by my lord, that the content of FIR is totally different. As you are very much aware of the fact that the allegation is because that has to be proved by
So
scrutiny
where is the
reporters of
latest order? The last order of the
Last-
trial court? 7-5.
no, my lord, page number 401.
Hmm?
401.
Four-
Yes.
Hmm?
41.
41 of your
Page number
petition.
41, yes.
What is that?
This is the bail order in which second page 42.
No, no, thereafter also it appears.
Yes. It was fixed on 9/4/25 for production of accused and for examination of the PWs. But on 9/4/25 again, no PW startup. And victim has been called since 17/12/2018.
No, so now you see, next date is already fixed, and on the next date, if the accused again remain absent, it will be again problem. Next date is already fixed.
Next day.
Thereafter, immediately after examination of the victim, we approach, it will be better. In such cases, it will be difficult. Let her examine first. Let her evidence be recorded, and thereafter, after next date.
Yes.
if I-
Otherwise, Your Honor, since 2018, it is
Maybe,
page number
but
37.
Maybe, but you see, the record speaks that you jump the bail, and then this will again be prolonged. The trial of the case. The case of 2016. 2016, this is 9 years.
But my lord, case was taking cognizance on 17/7/2018 by the learned session judge. Though it is of 2015 case, but it was committed to the session court by, then CC was to be framed on 17.
We'll grant the bail after the examination of the victim. If I, okay. This bail.
G.
Legal and not counsel for the petition. I've also had this, Land council, land, edition TP. How many methods we have? 5 methods. Are they urgent? I'll pass over. Yeah. Let us see. I'll pass over.
All right.
Hmm. Hmm. Yes.
Lordship, this is application for anticipatory bail.
Accepted by the interim order.
Yes.
Okay. So what happened?
Lordship, I would like to make systematic submission. So.
Yes.
CD we have received, my lord. And his statement.
Well, after obtaining this interim bail, so whether you appeared before the eye of the case,
Yes.
when?
The exact date is not with me right now.
Okay. You have no record of your no record of the accused appearing before the eye of the case.
Lordship, after getting the interim order, we have appeared before the IO and we have furnished the bail bond amount also, the 20,000.
Okay. So we have been shown arrested.
That, no, that prosecution will not, Your Lordship. Because we have appeared before the
Mr.
IO,
Can you
we have
see
given out statement.
whether he was arrested, shown arrested?
Yes, your lordship. He was arrested on so and so. Yes, your lordship. He was shown
Released
arrested.
also.
Arrested and released on bail bond, your
Has
lordship.
become infractus.
No, no, my lord.
No.
No.
He was
Either
arrested and
the
released on bail.
idea
What is the allegation against that?
your lordship, actually what my humble understanding so far as your lordship executing the bond is concerned, it is basically your lordship when interim protection is granted, the court always give a direction in the event of arrest.
Yes.
Now the investigation officer has two choice, either not to shown him arrest. If not to shown him arrest, there is one difficulty will come on the later stage because
Right.
to secure his presence later on.
Right.
But once any surety has been taken or the bond amount is taken, and if he does not comply on the later part, then it can be cancelled before the trial court also, not by the high court. For that aspect only, your lordship, that has to be looked into. But so far as this allegation now, your lordship, since his statement has already been recorded. Now the only limited, your lordship, the issue would be whether his detention is required or not.
Yes,
that much, your lordship.
Now, since
now-
he has appeared
and cooperating with the investigation.
cooperating,
So,
statement also recorded.
yes, your lordship. In my humble understanding, his further custody, in fact, is not deemed required. I'm fairly submitting, your lordship.
Okay.
Because, your lordship, the bail bond is executed and he's a local, he's a person staying here. So, with an strict condition that he may not dissuade the witness any statement and he shouldn't try to contact the victim. By imposing such strict condition, your lordship, this bail can be made absolute, your lordship.
Mr.
Egambe.
Lana counsel for the petition. I've also heard Mr. Eke, Lana additional PP. For the state of APM staff. Correct. By in order dated 23/4/2025. While calling for the case title. The accused was protected by an interim order. With a direction to release him on interim anticipated on execution of bail bond of rupees 15,000. With one local surety of like amount. Like amount with the further condition that the accused, with the further direction that the accused shall appear before the eye of the case, with the further condition of not the agent, that the accused shall appear before the eye of the case, as in when called for, and shall not appear, shall not directly or indirectly make inducement or promise to any person acquainted with the fact of the case so as to dissuade him or from disclosing such fact to the court or to any police officer, staff. The London Council for the petitioner submits that after obtaining him and there was hearing there on when he appeared, when
23rd April. 27.
On 27, your lordship,
on
because he was on arrest on 27, he appeared on 27 itself.
appeared before the eye of the case, and on 27 he was shown arrested. On 27 he was shown arrested. Shown arrested and on execution. Shown arrested, on 27,
Yes, and released on bail bond.
and
yes.
released on bail on the strength of the interim order dated 23/4/2025 on execution of bond. Start. Mr. Mehta, while producing the case study, while referring to the case study, submits that it appears that after obtaining interim bail, the accused is cooperating with the eye of the case, and he was also arrested, shown arrested, and subsequently released on bail. And since the accused is cooperating, his further custodial remand may not be required. In view of the above, and in view of the above, and as the accused is cooperating with the eye of the case, so bail has already been, and also he has been shown arrested and released on bail in terms of the bail order dated 23/4/2025, the bail granted to the interim anticipated bail granted to the accused on 23/4/2025, which have made absolute. Regularized and made absolute and regularized on the same terms and condition with the further condition that what for condition you want?
Your lordship, he should not, he shall not, your lordship, try to contact with the victim of this case, your lordship.
Okay, what case was this?
Your lordship, it's a assault.
Assault. Okay.
Assault, yes, and there is an allegation that he has directed some other accused to assault the victim,
Okay.
and it's an 0 FIR from Tinsukia, your lordship.
With the further condition that the accused shall appear before the IO again.
Yes, as and
IO
when
of the
required.
case, as and when called, IO of the case, as and when called for, that he shall not tamper or hamper with the evidence of the case, and also not or try to meet
Contact
try
directly or
to
indirectly.
contact directly or indirectly to the victim of the case. What else?
That much, your lordship, that will suffice. Sir.
The other conditions are already there.
Yes, in addition to the earlier conditions.
Okay.
Yes.
Okay. This bail application shall be read along with this bail order shall be read along with the bail order dated 23/4/2025.
Yes, Your Lordship.
With the above, this bail application stands disposed of.
Your Lordship, the earlier interim bail granted on 23 for absolute with and accordingly this bail may be disposed of. Your Lordship.
That is right.
Yes.
Made absolutes, no?
Yes. And
Okay.
yes, sir. Deeply obliged. Sir.
At two, we'll continue at two then. I'm sure it will be 3 meters. No? This was 18. Okay, 3 more meters. Then we will continue at two. Okay. Anything? Huh? No, we'll continue at two. Continue unlisted as the last item. Yes.
May I please, Your Lordship?
Yes.
Lordship,
Not yet file affidavit, no opposition.
yes, Lordship. We need 2 weeks like that for Lordship to file an
Your
opposition.
Mr.
Takum Pavin, Lordship.
Takam Pavin,
Yes, Lordship.
Dana Council for your co-respondent,
Yes, Lord.
Dana Council appearing on behalf of the respondent. How many respondents are there?
One.
Okay. Appearing on behalf of the sole respondent, pray for further 2 weeks. Hmm? And praise for and is granted further 2 weeks to file affidavit in opposition. So, Mr.
Yes, Your Lordship.
Dana Council for the petitioner is present. Release this matter after 2 weeks.
Deeply obliged, Lordship.
Your Lordship, I have just received the copy of written objection. So I may be given some time.
Mr.
J. Karbak.
J. Karbak, Lara Council for the petitioner submitted he had just received the written objection filed by the respondent and for which he needs some time to go through the same. So, okay, Mr. D. Boji, Lara Council for the petitioner is also present. It's grateful by the Lara Council for the respondent leaves his matter after
3 weeks.
3 weeks. Okay.
All right. Lordship, there is an interim order. May we continue?
Stop. The interim order passed earlier shall continue till the next date of this thing. Okay.
Obliged.
No one.
Lordship, I appear for item number 21 for the petitioner, Your Lordship.
Okay.
Lordship, in this case today we have filed one additional affidavit which is not on record, Your Lordship. May I pray the matter will be listed next week?
Okay. Mr.
G. Bordlo, Lordship.
G. Bordoloi, Land Council for the petitioner submitted he has filed additional affidavit. When did you file the additional?
Today morning, Lordship.
Today?
Today morning, Lordship.
Okay, today morning itself, which is not on record. In view of the above, let the matter be listed after a week. Stop. Mr. Again, Land Council. The land additional PP for the state is also present. Okay.
Obliged, Lordship.
My brother seems to be busy in court number 1, man.
Okay.
CBA, counsel for the CBI.
Then
Can be done tomorrow, my lord, if possible.
Mr. P. Kapoor, land council for the petitioner is present. You are appearing on behalf of Ms.
M. Kato.
Okay.
M. Kato.
Miss, land council appearing, land council. Some steps, Mr. M. Kato, land council appearing on behalf of the respondent. He is on leg in another court. In view of the above, let this matter be listed. When?
Tomorrow, my lord.
Tomorrow, list already prepared. It may not be possible.
Day after tomorrow, my lord.
Day after tomorrow.
Yes.
Okay.
Obliged.
What is this matter about? By the
My
way?
lord, basically, what happened here is, the main accused is the husband, my lord. Husband who took loan from the bank. The bank said he is fraudulently taken the loan, though he already had a well loan earlier also. So that's why the only allegation against the present applicant is that she is wife of the accused person. That's why. What we are submitting is, in that case, every act of husband, the wife would be liable. The conspiracy, Lordship, I clearly appreciate for the conspiracy, then every wife will be liable for conspiracy of husband.
Husband is still there.
No, that's what the charge sheet is.
Anyway, day after tomorrow. Okay.
Obliged.
In the item number 21, Lordship, this counsel is for the complainant, Lordship.
What's it? Item number 21, I'm the complainant, Lordship. But
What do we do? What order was passed here?
Lordship, next week, Lordship, because they have to file IA from the petitioner side.
Okay, you want
I have not been implemented, Lordship, but
not been impleted?
yes, in this matter.
Let the council appear and we'll ask him to implead. If not impleted, when it is listed, it will be listed next week.
Yes, Lordship, next
And
week.
then next week you appear, okay? We have, no, no, this is, I think. No one appeared. This is. Bail. Why you need to mention it? No one appears. List is matter again. Then day after tomorrow. So. No one appears. No? Same order. No one appears on the floor. Huh? List is matter again. Day after tomorrow. Why after mentioning the present? Okay.